Item number 108. I am the
108.
appellant bank, your lordships, and there is a order of the Honorable High Court restraining the bank from dealing with an asset which has been taken by under the Surfacy Act. Now the issue is, your lordship, that public money is involved, and day after tomorrow is the auction, because I had taken possession of the property long back. Now the auction is there day after tomorrow, and in the meantime, the respondents have approached the Honorable Court, and they have taken a restraining order regarding by suppressing material facts. Now I will be in a very false position, because since I had taken the possession, it is just day after tomorrow.
Now, have you informed the respondent?
Yes, I had followed all the procedures
We
by
will-
giving a notice.
We will upgrade it tomorrow.
If it can be taken in the list tomorrow and the top of the list, your lordship.
Yes.
May I seek, my lord's kind indulgence to seek leave to file this mandamus group 4 appeal with server copy, my lord.
Yes.
Grateful lordship.
May I kindly to mention, my lord, the bank security has been directed to be released, which has been placed with another loan. But that's the gold loan. Gold loan has been, the gold has been directed to be released, which has been placed with other loan.
Yes, because they have got the banker's lien.
Yes, my lord, the learned single judge has come to the conclusion that the gold has to be released because there is no general lien, which is contrary to the documents placed before in the bank loan application itself, my lord.
You filed the appeal?
Yes, I have filed it appeal. Let it be appear on 20th, or my lord, that group 9 appeal is being taken on 20th.
Yes, yes.
My lord, kindly take it up.
Yes.
My lord, may I be permitted to mention 5 analogous applications? My lord, where my lord, your lordship was pleased to get the matter listed for new motion. But not it been listed, my lord.
I was not there for a week now. You give the letter wheels.
5 my lord analogous applications are there.
Okay.
And my lord, your lordship was pleased, note, so that the matter would be listed.
Yes.
These are the new applications.
You please give the letter today itself. We'll check.
May it please your
Madam,
lordship,
may I have your lordship's leave to mention
Yes.
this matter was dismissed for default, though it was not listed. But I have checked it, even the order dismissal order was uploaded in connection with another writ petition.
Then you give it, we list it to be mentioned. Yes.
May I have your lordship's kind leave, my lord? My lord, the union is in appeal, my lord, against an order, my lord, whereby, my lord, the lookout circular that has been, my lord, quashed, my lord. My lord, there is tremendous urgency in view of the fact, my lord, the SFIO, my lord, had issued it, my lord. There was another lookout circular at the behest of the bank. Now, the circular at the behest of the bank was under challenge in the writ application. But essentially, my lord, the SFIO circular has also been now, my lord, quashed, whereas an investigation is pending. The investigation was not challenged.
If that was not the subject matter in the writ petition, how it can be quashed?
My lord, it has been, my lord. That was a specific point, my lord.
You have filed the appeal? You have filed the appeal?
I have filed the appeal, my lord, upon taking leave from the honorable my lord, division bench presided over by the honorable.
Yes. No.
My lord, the only my lord, predicament is, my lord, considering the peculiar facts of the case, my lord, there is a stay of operation of the order till my lord 19th, my lord.
That is day after tomorrow. Tomorrow.
My lord can take it up day after tomorrow also. I understand day after tomorrow if the matter is there in the
Day after tomorrow.
Grateful to you, lord.
I'm praying for liberty to file a group 9 appeal with server copy.
So, leave granted. Yes.
The public interest litigation, which was moved, my lord, on the 15th of September, affidavit directions granted. Affidavits, my lord, will be filed by the 16th of October. My lord, the only thing is, my lord, we could not ask the other bench for, my lord, fixing a date because it would come back before your lordships for hearing. And there is some urgency. There is an order for, my lord.
But how to your date has been given by 16th October.
Yes, my lord, affidavits will be completed by that date. But a date for hearing, my lord, could not be given because it would come back before your lordships.
Probably if you can mention it on 16th October, on the date it will be listed. We list that on 16th October.
And I'm for the state, your lordship.
And for expeditious hearing.
Yes, ground pleader is there.
Had been passed by your lordship, and I have annexed the lordship's judgment and claim for same order for final disposal.
Yes.
2 matters, lordship.
It's a group 9. It's a group 9 appeal. Okay.
may please your lordship, I seek to mention a matter upon notice, my lord. My lord, I'm seeking urgent tender number and leave to file without certified copy in respect of an appeal, my lord. My lord, there is some urgency in the matter, my lord.
You file it.
Very well, my lord.
Well, may I be permitted to mention,
my lord, there is urgency in the
The
matter.
moment it is numbered, it will come. Fresh
Very well.
motions will come.
My lord, may I have your lordship's list to mention a matter? My lord, this is an application
against which, my lord, the contempt application has been filed. And, my lord, on 8th September 2023, my lord, the Honorable Court was pleased to adjourn the matter till 29th September. Urgency is that, my lord,
But how to advance the date? Unless you file some application.
no, application is,
early
my
hearing.
lord, in the list. Every Friday it is appearing as under the heading application, but the matter is not being taken up. So that is the, I'm facing the
You want it
difficulty.
to be upgraded on.
Yes,
Friday.
my lord, kindly, please.
May I have your lordship's kind leave to
Thank you.
mention a public interest litigation. It is with regard to a marine fishing product, which a loan was given and a subsidiary amount was given. The subsidy amount was disbursed, but loan was, there is irregularity on that, which I have portrayed in the canvas.
Your file, it's a fresh matter or it's running in the.
My lord, it was a matter which has not moved once. I have mentioned this matter. This is a 2020 matter.
2020. You give.
I have mentioned this matter.
Yes.
earlier.
My lord, may I have leave to mention one matter, my lord? My lord, this is a writ petition relating to the distribution of funds to puja clubs, organizers. My lord, I have filed an application. There was a writ petition pending. My lord, I have filed a new application for this year, my lord.
That application we listed.
My lord, my lord.
But last year, I think some direction was issued.
My lord, these directions were issued. We have the state.
Some accounts we read
Yes,
in the
my lord.
newspaper.
My lord, may I? My lord, one short consideration, my lord. My lord, they'll distribute the funds, my lord. Kindly list it urgently, my lord.
We list the application, let us see.
Grateful.
My lord, may I have your lordship's kind leave to mention one urgent matter? My lord, this matter was moved before, my lord, the division bench, my lord, presided over by my lord, Mr. I.P. Mukherjee. And their lordships were given an order of stay, my lord, for a period of 2 weeks, considering the urgency. Now, my lord, the stay will be, my lord, inoperative, my lord, on 25th itself. If your lordship kindly take up this.
24th, it can come up.
Lordship. Grateful.
May I kindly mention, my lord?
24th. No, 24th, 25th, it will come up. 25th is a Monday.
My lord, I am protected till 25th only, my lord.
25th, it will come.
Lordship.
May I kindly mention, my lord, two matters. The very first matter is that a final assessment order under section 147 has already been passed. The writ petition was pending by that time. The writ petition is dismissed. My lord, anytime recovery will start.
Yes.
Kindly this matter be
Then
listed.
what is the second matter?
The second matter is that a 148 AD order was passed. It was challenged. It was completely based on surmises, conjectures, and it was dismissed.
All right, both appeals.
So may I be permitted to mention one appeal by the Chief Regional Manager of Hindustan Petroleum filed in 2011. I am for the Lordship decree holder.
2011.
Yes, my lord. I won the writ petition in the year 2010. The authority preferred an appeal against the order of directing upon this
On notice
authority.
you mentioned, because to the old matter, suddenly it is listed. They
I
not
will
be
give
ready.
them the notice if your lordship.
No, after notice you mentioned, probably tomorrow, day after.
Lordship,
Because otherwise they'll have to contact the client.
lordship, I will do that.
The day after tomorrow you mentioned, after upon notice, if you can get them here, it will be good.
It would be good, but lordship taking the advantage of that situation, they are not implementing the order.
Or you could have filed an application for vacating the interim order or something.
There was no interim order. The appeal was never been heard. This pendency, they're taking the advantage of
You
pendency.
mention after notice.
Lordship, I will give.
May I have my lord's kind leave to mention a public interest litigation? My lord, this public interest litigation appeared on the 14th of August, when my lord had directed service on the respondents. My lord, I took steps to effect service. However, we found that the addresses of the respondents, private respondents, were changed. So in such circumstance, my lord, we have taken out a can for to change the cost.
You list the application.
My lord, for inclusion. May I hand over this?
Diptesh, list the application.
The application along with the
Yes,
public
it
interest
come.
litigation.
My lord, may I be permitted to mention item number 52 of your lordship's list?
Yes.
It is a public interest litigation, my lord. One Adivashi Kurmi Samaj, my lord, declared rail blockade.
I think it may reach because let us see item numbers 4 to 15. 4 to 15 are connected matters.
I'm only prayer if your lordship, if it's not taken up today, if it can be taken up tomorrow, because my lord, they
Let's
have
see,
declared band on 20th.
4 to 30. What is this matter? Oh, 4 to 30 is election matter.
My lord, only one predicament, my lord, that is the band they have declared on 20th. That is on Wednesday, they have declared.
Let's see, no. You please wait for some time. Yes, sir.
May I have a lordship's leave to mention, this is a contempt matter. This was appearing in the list on 15th last. My lord, I just request your lordships to kindly have a look of your lordship's order at paragraph 11. I'm hand to mouth now. Since 97, I'm working your losses directed, affirming the judgment of the learned saint. Paragraph 11 only. this order has not yet been complied with by this state.
Well, what is the contempt application number?
Content application number.
You give that, you give a letter, you list the contempt application.
Well, this was in the list. My lord, all the time paying your losses, fix a date and permit me to serve upon them.
Let it appear in the list once again.
All let your losses.
Lordship, may I
have your
mention
lordships?
one matter for upgradation? This
It is
is,
in the monthly list.
yes, monthly list item number 235, my lord.
235.
Illegal,
What is the urgency?
illegal construction over the government land and also encroachment of khal, my lord. This is the appeal application, my lord. Illegal construction remain,
But you have, informed the other side, you given notice to them.
then,
Upon
my lord,
notice, if you can mention, day after tomorrow.
yes, my
Huh?
lord. Great, please.
May I have your lordship's kind leave, my lord, to mention item number 117 and 118 of the monthly list for upgradation, my lord.
What is the
My lord,
urgency?
the urgency is that, my lord, a huge consignment of beetle nuts is in the custody of, is in the,
Earlier also somebody mentioned.
my lord, it
We
has,
will not, there's no
my lord,
urgency.
the goods are of perishable nature, my lord.
Suppose we move this list today, probably it will be included there by day after tomorrow, you will come inside the daily list. You please wait. Yes.
May I be
So-
permitted to mention item number 382 of monthly list, my lord. The urgency is, my lord, there is a constant water logging in the Bali Jogacha area, and during this rainy season, my lord,
Give the letter, let us.
My lord, may I be permitted to mention, my lord, 812 of the monthly list, my lord. The urgency is that, my lord, he's a senior citizen. My lord, his work order has been terminated after the work has been completed. And then, my lord, the machineries has been seized by the
And
respondents.
who appears for the respondent? Which organization? Government?
My lord, PWD,
State government?
my lord, state government.
Anybody is there? You please inform the government leader and come back on Wednesday.
Wednesday.
My lord, may I be permitted to mention one matter for upgradation, my lord, item number 297 of the monthly list, my lord. My lord, the urgency is this, my lord, every day, my lord, tea is being imported from Nepal, my lord, without following the food safety norms, my lord, which is, my lord, hazardous for human consumption, my lord.
This is a public interest litigation.
Yes, my lord.
Give the letter, let us. Yes.
My lord, I have served upon all the respondents.
But I'm praying for the inclusion of a group 9 application with some parity, my lord. This matter relates to Surrogacy Act, my lord. The petitioner's application for surrogacy was rejected on the ground of being overaged. That has been set aside by the Honorable Single Judge and sent for reconsideration before the state authorities. They have filed an appeal, my lord, from that order, my lord, but
You
not.
give the.
My lords, may I have a kind leave to mention item number 684. This is the second time I'm mentioning the urgency for upgradation is, my lords. I'm the owner of a plot of land. Under the government of West Bengal, I have been accorded to develop an industrial park. Now, somebody has filed a PIL, the petitioner, against me, alleging that I'm not the owner of the land limit is exceeding and stuff. Now, the kindly up-
Lordship, kindly to prefer, I will use server copy of the
Leave that.
grateful, my lord.
Please
My
call.
lord, may I be mentioned?
Yes,
Original side matter, my lord.
original side.
Yes, my lord. Your my lord, writ petitioner, we have dismissed by the land single judge. Thereafter, appeal was preferred. My lordship was pleased to direct them to deposit 1 crore rupees. My claim is more than 13 crores. Today is the 15 crores, my lord. Is the order, eviction order passed by the estate officer. Thereafter, my lord, writ petition was dismissed. Your lordship was desired to hear out the stay application. My lord, matter was directed to appear on 19 July, my lord.
It's not appeared.
Not appeared, my lord. My lord, we are not getting any monthly rent,
Original,
nor we are getting the arrear rent.
original side matter. You please give.
The urgency is this, notice.
Yes, please call the list.
Appellate site, daily list, serial number 1.
well, I'm for the respondent number 11.
I picked up on behalf of the petitioners.
From outside, lordship, I want to make a submission on behalf of respondent number 11. There was a direction for his appearance. He is present in the court today also. Lordship, there was another direction upon him to file an affidavit stating that he does not intend to make any application for the nursing college, run the nursing college, as well as, lordship, another affidavit to the extent that certificates which were there with him shall be
Yes.
returned to the
Paragraph
petitioner.
6.
Yes.
The 11th respondent shall file an affidavit
Yes.
clearly setting out the facts that he does not propose to run any
Yes,
nursing,
my lord.
given undertaking to.
Yes.
Where is the?
Well, there was one predicament, lordship. So far, the second part is concerned. Second part, return of the certificates. The certificates, lordship, according to my, I have checked it. It says that Muhammad Zia ul Haq, the another person who is not appearing in the court on the last occasion, there was a direction. It was in his custody. When my client was arrested and was taken into police custody, those documents, he had cooperated with the police and he has deposed to that effect that all these documents are with Ziaul Haq. And Lordship,
Where is that Ziaul Haq?
that is the this
Your Lordship directed me to, I am appearing for the state, your Lordship directed me to, serve a police to serve a notice upon him. This is my report in that respect.
But now they are appearing through counsel. Where is your client? Please? Your client is here?
Your Lordship, kindly, it was 2 weeks time, my client will be.
No, this certificates and credentials have to be returned. Otherwise, he is not going home, he is going to the correctional.
Your Lordship, kindly record. It's lying with my client, definitely.
He sent an email saying that he will appear on 16th before the Bankura police
Your Lordship,
and
the
give a
next page,
statement.
your Lordship, next page that email is there.
And he said he will come and appear before the court today.
Lordship,
Where is he?
my lord, specific direction that both of them should personally appear before Lordship.
No.
It's not done, my lord.
See, this is playing with the life of students.
yes, ma'am.
So let him run some commercial establishment.
Kindly see the next page.
It's
Your
the,
Lordship, kindly see.
this is a fake educational institution. He is actually sort of a broker for collecting the credentials of candidates. Probably they don't even attend classes. Certificates are given. And what is the institution? It's a nursing institution. And imagine, and those people are going to be employed in the nursing homes here. No, let your client appear. And if he is able to comply with the direction, because the 11th respondent says the credentials are of your client. So therefore, let him first return it.
My lord, may I please your lordships? My lord, there are a few things which I want to draw the attention of this honorable court. My lord, first of all, the anxious.
Unbelievable, sir. Air ticket is not available between Bangalore and Calcutta.
My lord, there are quite a lot of things going on behind the scenes. My lord, the first thing is this. Out of blue, now that they are claiming the thing that this particular organization is being affiliated to to some university which is outside the state. It is in southern part of India. But curious enough, in the year 2012, it is the same government that has stated that this particular organization is fake. It is illegal. Now they are coming up with the plea that it is somewhere settled in Bangalore. My lord, the thing is this: the particular or university that what they are submitting, the address is not yet been specified. And moreover, my lord, there's few more things to be ascertained. Whether that university, even if it exists, whether it is legal or not. Otherwise, it is.
So first what we will do is, we will ensure that the 11th respondent complies with the earlier direction. And he files an affidavit. In that affidavit, if your 11th respondent says the certificates are not with him, and it is with Ziaul Haq, let him state so in the affidavit.
Yes, well.
Ziaul Haq will appear on the next hearing. When? Day after tomorrow?
My lord, one more thing.
No, let him appear.
No, I'm not talking about the
will
appearance.
take it stage by stage. They can't
Step
be
by step,
hoodwinking everybody.
Other students are also deluging in.
No, see, once he has come and he has given you a wakalatnama and engaged, obviously he is present somewhere. So let him not. It's very easy to secure him. But if we secure him through a court order through the police, he is not going back to Bangalore. 100%.
Another
Send him to Purulia correction.
Another problem,
Not to
Lordship.
Malda.
When my client was picked up by the police and arrested because there was an application for anticipatory bail which was filed before this court, which was rejected. Thereafter, my client surrendered and he was taken into custody for a substantial period of time. And Lordship, these persons were never been arrested. This Ziaul Haq and others. I inquired.
Now that
Lordship, these are the
it's
things, Lordship. Let
good that a counsel is appearing,
Shahid Ali made a party and a copy may be served because we don't know what the
no, copy. Yeah. He knows what is that. You can give him one set of.
I will, your lordship. My lord,
Day after tomorrow he'll appear. When he'll appear? Bangalore is.
3 hours.
From Bangalore to. It is 2 hours 10 minutes.
Can you give me this Friday?
Thursday.
My lord, kindly can it be made on Friday because I have to attend one funeral Shraddha ceremony, my lord. Can it be fixed on Friday?
There may be some difficulty because the bench.
Because my father-in-law passed away, so I have to be there. So
Then on Monday.
yes, your lordship.
Reference may be made to the order
My lord,
stated.
can it be made on Friday because I have to attend one funeral Shraddha ceremony, my lord. Can it be fixed on Friday?
There may be some difficulty because the bench.
Because my father-in-law passed away, so I have to be there. So
Yes. Then on Monday.
yes, your lordship.
Monday.
Yes,
Reference may be made to the order.
Can it be made on Friday because I have to attend one funeral Shraddha ceremony, my lord. Can it be fixed on Friday?
There may be advocate appearing some difficulty because the bench.
Because my father-in-law passed away, so I have to be there. So
Enable. Then on Monday. Comply with the directions issued in the order of 6 of the order dated 4 January. Made to the order. Let's check out the 11th respondent. Advocate appearing some difficulty because the bench. Raised for 11th respondent. Then on Monday. Comply with 25 directions issued in the order. 6 of the order. Same order. We are directed the respondent police to ensure the presence of Ziaul Haq / Shahid Ali of Alexander Educational Trust, Bangalore. The inspector in charge, Bankura Police Station, has filed a report from which we find that Ziaul Haq / Sadiq Ali had sent an email to the police stating that he will appear before the police on 16th September 2023 and give a statement. And thereafter he will appear before this court on 18th September 2023. Both of the above commitments made by the said person, while his email dated 12th September 2023 has not been complied with. Today, Mr. So-and-so learned advocate appears for the said Ziaul Haq / Sadiq Ali. Let Ziaul Haq Sadiq Ali appear in person before this court on 25th, failing which coercive action will be taken against the said person. List on 25th in the same caption. The 11th respondent shall continue to be present in court on the said date. You ask him to file an affidavit.
We are grateful, my lord.
Yes, next.
much with this, your lordship.
Serial number 2.
My lord, in this matter, I am for the respondent bank, my lord. My lord, perhaps no notice was given to me at the time of upgradation. It suddenly came up. My lord, be that as it may, at the very outset, my lord, I would raise one question with regard to the maintainability and entertainability of this writ petition, because this writ petition or writ petition of the appeal, because it purports to challenge an action of the bank taken under the SARFAESI Act.
Yes, sir.
My lord, your lordship has seen, my lord. In the impugned order, rather the judgment of the learned trial court. Internal page 3.
Yes.
At the bottom.
Yes.
The bank has also placed a document of 7 January 2023, which contains the signatures of the petitioner for making an inventory of the movable assets. Now, where is this document of 7 January 2023? The 7 January 2023 document, your lordship will kindly find page.
Where is the copy of the writ petition?
Writ petition. But it has not been annexed.
Why it is not?
Unfortunately, it has not.
What was the
been.
prayer in the writ petition?
No, the writ petition will come. But let us see, my lord. First of all, your lordship will kindly see. The 7th January, that notice.
It's in page number 55.
Stay application at page 59.
59.
Of the stay application.
Yes.
At page 59.
Panchanama.
Well, the lordship goes on page 59. Just on top. Appendix 1. C rule 4.1. This is 7 January. Lordship will kindly see, my lord. 4.1, rule 4.1 deals with regard to the taking over of the possession of the movable properties. Now, what does it say? Towards the end. So and so, the names are there too, then borrower on its non-payment taken over possession of movable properties as detailed in the main inventory attached to the Panchanama between so and so. So therefore, it is a movable property you are taking possession. Exercising your power under Rule 4.1. How come that you can throw me out of the house? Taking possession of the immovable property? Now, my lord.
But then the district magistrate has passed an order on 10th of
But
March.
the district magistrate is not the arbiter.
Pardon?
District magistrate has to render an assistance.
No, the moot question would be how a writ petition is maintainable. Your remedy lies elsewhere.
No.
Any action or any measure taken under the provisions of the Sarfasi Act is justiciable before the debt recovery.
But my challenge was not as to whether the district magistrate was
We
exercising.
are not here. Some urgency is there. You will file a writ petition, obtain it.
My challenge is much more basic. Much more basic. Well, it is a loan agreement.
All points can be left open. You please go approach the debt recovery tribunal, file whatever application you want. Action has been initiated under the Sarfasi Act. Every measure is liable for challenge, including an order under 14.
But your lordship will kindly examine the finding of the learned trial court as to whether it is in accordance with the documents produced.
The petitioner took the risk of approaching the writ court in the interregnum without following the procedure which has been provided for under the Sarfasi Act.
But if the entire action is totally without any jurisdiction, then it is the writ court that will exercise its jurisdiction.
The Supreme Court has made it very clear.
Well, yes.
Any measure under the Sarfasi Act, your remedy lies there. The remedy is more effective in any step, right from the stage of 13.4, section 17, you please see. So you please invoke
But I beseech your lordship's observation. My lord, I am also on the Supreme Court judgment. I am also on the Supreme Court. My lord, I have all these judgments, my lord, I will place before your lordship. My lord, the entire action started with an agreement for loan. An agreement for loan, my lord, it is not wrong. It is not a sin to get a loan from the bank, because even in the state takes bank loan from other authorities. So it is, the loan is an approved situation. I have taken a loan is an admitted position. The bank has given me loan is an admitted position. But it is not an oral thing, but it is not a written agreement. And the written agreement is there. The written agreement contains the condition as to how the loan should be repaid. No matter the basic document is that.
It's an admitted fact there's a default. And the petitioner would come to say that the bank should have taken a soft attitude, it should have waived the interest, etc. All those reliefs are with the bank.
I am not on soft attitude.
No.
You don't have to show me mercy.
No, that's the pleading in paragraph 8, page 12 of your memorandum of whatever it. What is this? It's a memorandum.
Yes.
Stay application, page 12, para 8.
Page
So
12,
suppose you want a waiver,
My lord.
you please make an offer to the
I'll
bank.
come to page 12, para 8. Yes.
Para 8. And you have said that before classification as an NPA, no notice was given. That is also an issue which can be raised.
My lord, then, my lord, the entire procedure, my lord, even taking over of the possession of a property.
We are not saying it. See,
My lord, the bank is entitled to take over the possession of the secured asset.
exactly.
But that possession has to be taken in accordance with law. And under the particular statute under which you are exercising your power.
If you want the findings to be vacated,
Yes.
rendered by the learned single bench, we grant you permission to withdraw the writ petition.
My lord.
In this appeal, we will grant you permission to withdraw the writ petition, giving liberty to approach the debt recovery tribunal for seeking whatever remedies you. That's the best we can do. That's the best we can do.
My lord, if I withdraw the application, my lord, should I come with another appeal?
No. Withdraw the writ petition. This is an intra-court appeal. Your writ petition was to set aside the communication dated 3rd January. The learned single bench has gone through it and rendered a finding. There is nothing wrong procedurally, no procedural error committed by the bank.
Yes.
So if you want, you withdraw the writ petition, which liberty will grant. Consequently, the findings rendered by the single bench will get effaced. You approach the debt recovery tribunal.
My lord, with liberty to file a fresh writ petition?
No, that can't.
My lord, the thing is, pardon? My lord, what I am challenging before your lordship is, my lord, the order of the learned trial court. Now the learned trial court relied upon a particular evidence, particular document. The document is said to be that 7th January.
But you can't.
That is with regard to the movable property.
No, sorry for interruption.
My lord, the other order also your lordship will kindly see in the memorandum of appeal.
Internal page 2 of the order.
No.
You see, the admitted facts which should appear from the material placed before the court are that district magistrate passed an order on 10th March in relation to so-and-so decimals of land with 2-storied building to make necessary arrangements for taking over possession. Physical possession on the property described in schedule in a certificate of possession was taken over by the executive magistrate on the said day. The petitioners have admittedly not challenged the order of the district magistrate or consequent possession of the petition.
But I must have the copy.
See, you are before a wrong forum. You are before
That each under the statute. Under the statute, my lord, that all the order that has to be made in accordance with the statute. My lord,
what we are trying to impress upon the learned senior counsel, that your remedy lies elsewhere.
My lord, your lordship,
appellant thought fit to take a risk by approaching the writ court. He has invited this order.
My lord, your lordship, kindly judge, my lord, the order of the learned trial court, because there is another order. Your lordship has seen, my lord, how the entire the another order.
Page 50.
No, other order. Yes. Page 50. Yeah, page 50.
50.
Page 50 of the stay application. Page 50 of the stay application. It is. Yes. But it is a fraud on power by the bank. Page 50.
Yes, sir. We have heard you, sir. We have heard Mr.
Page 50, your lordship says.
Learned senior advocate for the appellant. This
There is no further notice.
Is directed against the order dated 7/2/2023 in WPA 1054 of 2023. In the said writ petition, the appellant prayed for setting aside the communication issued by the respondent bank dated 3rd January 2023. The ground of challenge is that the bank has taken physical possession of the residential house of the appellant without due recourse to the relevant statute. The learned single bench, after taking note of the facts, has recorded that the district magistrate has passed an order on 10th March 2022 for taking over possession of the secured asset of the borrowers who are the appellants before this court, and the physical possession of the immovable property described secured immovable property in a certificate of possession dated 7th January 2023 was taken over by the executive magistrate on that date, and the appellant has admittedly not challenged the order of the district magistrate or the consequent possession of the immovable asset. The other aspect with regard to the notice issued with regard to the compliance of Rule 4 of the security interest within bracket enforcement bracket close rules 2002 was also examined by the learned single bench, and it has been pointed out and it has been held that the bank had placed a document of 7th January 2023 which contains the signatures of the appellants for making an inventory of the movable assets at the time of taking possession of their immovable secured asset. Accordingly, the writ petition was disposed of, granting liberty to the appellant to remove all the movable assets within the secured asset, within bracket house, as mentioned in the inventory, in the presence of the representative of the bank within a time frame. Thus, we find the order passed by the learned single bench is a well-reasoned order and does not call for any interference. Accordingly, the appeal fails, dismissed. Sorry, sir. Next.
Well, the 10th March, the district magistrate order has not been supplied to us.
You make a request. Next.
But he also had directed us, them to.
No, sir. It will be slightly out of. Yes, next. Upgrade this application position within the first 15 cases.
I appear for the appellants, madam.
Yes.
In this matter, what has happened, the rate petitioners, the rate petitioners were the borrowers. A loan was sanctioned and the amount was disbursed.
This matter, it has been mentioned before the other bench, Justice Mukherjee's bench. All of a sudden, my lord, we got notice, but my lord, when it was mentioned, we were not there.
Yes, yes, it was mentioned upon notice, madam.
I know, I've said I've received notice, but when it was mentioned, we could not go there. But there is as such no tearing urgency. If I'm led by Mr. Moinak Bush, if it can be taken up on Wednesday, my lord, he's not in town.
Well, it's their urgency because they are pushing up with their contempt application.
Contempt is on 6th of October, my lord, and nothing is happening in the contempt.
Wednesday, same position.
Yes, my lord.
Well, let it be on same position.
Same position. We have heard so and so. At the request of the learned advocate for the respondent, list on Wednesday.
My lord.
The same position. Next.
Rupak Ghosh. Rupak Ghosh for the respondent.
May it please your lordship. Lordship, these are the panchayat matters. Lordship, on the previous occasion had said that my matter, lordship, item number 9 would be treated as the lead matter. Lordship, I'm being led by Mr. Guru Krishna Kumar. Lordship, I have a request, lordship. It's extreme embarrassment only I'm asking.
No.
If it could be posted on the 21st, lordship, the 21st, the contempt matters is there. Mr. Kumar is will be coming down physically. If it could be posted on that day, then you could do both the matters physically, lordship.
In that event, lordship, you kindly fix it on 25th, not 21st.
Lordship.
25th or 26th. So that all we can argue. It's an important question of constitutional law.
Milord, I am Raman here, Milord, representing the State Election Commission. Would your lordships hear me?
Yes. You are audible.
Yes, Milord, in this matter, actually, one of the things I wanted to, Milord, also address your lordship and place something for your lordship's consideration. In the contempt matter, Milord, which Mr. Guru Krishna Kumar has already argued elaborately, it is now posted on 21st for his continuance and for his conclusion of arguments on that day. Your lordships, Milord, I have heard the entire gamut of facts weigh the nature of contempt. I have now been, Milord, engaged to represent, Milord, the State Election Commission in one of the four main matters which are listed before your lordships, which is, Milord, writ petition number 353 of 2023.
Yes.
But from the pleadings which I could make out, subject to corrections by my learned friends, substantially overlap, Milord, all the allegations made in the contempt petition. Wondering whether your lordships want to, Milord, defer the hearing of the writ petition till the contempt is over, because otherwise there'll be two benches, Milord, parallelly hearing same set of facts in respect of the elections.
All right. What we can do is we tentatively list this matter on Monday, 25th.
Yes, Milord. On that day, your lordships can take a call.
26th, if your lordship kindly excuse me, let it on 26th, 25th, but I have some difficulty.
On 21st, we will hear the contempt.
Yes, but
maybe.
contempt, your
That's a
lordships
different.
will, on 21st, your lordships will conclude Guru Krishna Kumar's arguments on the contempt, and I will be requesting your lordship for an accommodation for an early date after that. But 25th, your lordships, or 26th, your lordships will list these batch of writ petitions and take a call on that day how you would like to proceed.
Yes, in fact, the writ petition should be heard on the question of maintainability and the constitutional applicability. That's more important.
In fact, one of the argument of Mr. Krishna Kumar was referring to Rule 19 of the Calcutta High Court Contempt of Court Rules, 1975.
He wanted rule to be issued first.
So therefore, if suppose after he concludes Probably we'll hear you on whether rule has to be issued or not. If once we come to a conclusion, rule has to be issued, matter has to proceed further, or we decide otherwise. So that will be the scope of the hearing on 21st.
Yes, but that's what on 21st, Mr. Guru Krishna said he may take another half an hour to 45 minutes actually. I may require some small accommodation on that, but I'll be there, my lord, on 21st. I won't be coming physically, but I'll be there, my lord, on virtual court to my lord.
Virtually, sir. You can join virtually. There's no.
Yes, ma'am. Yes, ma'am. Yes.
Audio, video, everything is there.
But for the main arguments, my lord, I propose to come physically. And I'm going to make a request for your lordship, my lord, for October, because 2nd is a holiday. I want to be in Kolkata on 2nd and 3rd and finish the matter at one shot.
So for tentatively, we will adjourn the matter to 26th. This batch.
Respect of item number 4, my lord.
Yes, sir.
Where, my lord, we have paid for compensation. Adit Ranjan Chaudhary's matter. My lord,
compensation for the people who were injured.
Who were died and injured. My lord, in the report, my lord, it has been stated 54 persons had died just before the date of election, up to 50. One scheme has been, in the meantime, lordship kindly see, one scheme has been formulated by the state. Kindly see this only. But only I prayed for a report, my lord, how many persons has been given that compensation and employment. Because, my lord, I have informed that only 17 persons has been given. But as per report, 54 persons till 7th July. That is before the date of election. And on the date of election and after election, many persons died. How many persons have been given compensation and employment as per this scheme? That report should be come before your lordship.
That will ask the advocate.
I am before your lordship. I'll get the mallet. At for 14th July 2023 scheme.
The learned advocates for the parties seek for pray that the hearing of the writ petitions be deferred till the contempt applications in CPAN number 831 of 2023 and CPAN 948 of 2023 is heard by the other division bench. The request is accepted and let the matter be listed on 26th of September. The learned advocate appearing for the writ petitioner in WPA 351 of 2023 submitted that one of the prayers sought for in the writ petition is to grant adequate compensation to the persons who lost, to the families of the persons who lost their life in the violence which occurred during the Panchayat election and those persons who were injured. It is pointed out by the learned advocate for the petitioner that the government of West Bengal has issued an order on 14/7/2023 stating that that the state government has decided that one member of the family of each of the kin of the deceased victims who died in any incident related to Panchayat general elections, 2023 shall be engaged as home guard volunteers by way of special dispensation. Further, it has been decided that rupees 2 lakhs as ex gratia shall be paid to the family members of each of such deceased persons. The district magistrates were requested to send the details of the family members who are eligible to be enrolled as home guard volunteers by way of dispensation and also the details of the family members to whom ex gratia of rupees 2 lakhs shall be paid. The petitioner's concern is that it is not clear as to how many persons have been extended the benefit of the scheme, which has been put in place by the state government by order dated 14/7/2023. We find from the order that that the cases where persons were injured, some of whom who were grievously injured during the violence which erupted during the Panchayat general election, have not been given any compensation, nor there is any order to the said effect. Therefore, the state government shall, the appropriate authority of the state government shall file a report in the form of an affidavit disclosing the following details. Number one, the number of persons who, number of deceased victims. No, the names, number one, the names of the deceased victim who died in any incident related to Panchayat General Election 2023. Number two, the list of the names of all persons who have been engaged as home guard volunteers by way of special dispensation in terms of the order dated 14/7/2023. Number three, the names of the persons to whom rupees 2 lakhs was given as ex gratia, being the family members of each of the deceased persons. Number three, the state government shall state as to why the persons who were injured or grievously injured in any incident related to Panchayat General Elections, 2023 should not be adequately compensated. Let this affidavit be filed on 26/9/2022. List on so and so.
We're grateful, my lord.
As your lordship.
You want to file an affidavit in reply?
No, wait a second. I was just waiting to speak.
You have served copies? Copies
Your
have been received?
Yes. Lordships, item number 10, which I am appearing as petitioner in person, I have received their opposition, but just to save time, I am not giving any reply. I will do it while arguing the matter.
You argue the matter.
Lordships, grateful Lordships.
May I please, Lordship? My Lord, in respect of item number 8, I want to submit. I've got the item number 8, Your Lordship, for the petitioner. My Lord, our contention was that the school where the election have taken place, they have suffered a huge loss. Yeah. My Lord, there was a direction from this honorable court that let that loss be calculated by the state authority and proper amount of compensation may be done. My Lord, the state authorities have filed the report. They said that that particular loss has been assessed and yes, compensation is to be allotted. But my Lord, the irony is this: what are the institution which has suffered that particular loss owing to that election? That has not yet been specified, my Lord. My Lord, that is being the reason we are really apprehensive whether the school that has really suffered, the name should definitely be come up in the report. Otherwise, somebody else will get the benefit, while the actual school that has suffered the loss, that they will not get the compensation.
Can also be.
Lord, I have disclosed everything on affidavit. Now, my lord,
my lord, the names of the institutions are not
yet on arguments. My lord, on that day.
Then you file if you want to file a what is it called?
Reply.
Reply. Exception to the report, you file. We'll take care of that situation.
And my lord, in connection with item number 8, WBA 339, we have filed an application for addition of party. We demanded recall of Sambutsa, Malda, Murshidabad, and Purulia. We have not.
Who are the parties whom you want to add?
Their demanded recall, my lord, on the earlier occasion, your lordship recorded that application was allowed, and they have filed the opposition. We have not received the opposition in connection with can number 7.
And who has to file the opposition in can 7?
Can 7, my lord, petitioner name. In connection with WPA
can 7 in WPA 339.
Not received the opposition.
Is it Farhad Malik? Farhad Malik.
Farhad Malik case in connection with one Kobita Mahato, my lord, we have filed the application.
Sir, what is the prayer in can 7?
Yes, prayer.
Please read the prayer.
Yes. Under the appropriate facts and circumstances.
Next page.
That your lordship may be graciously pleased to allow this application for addition of party in the main writ petition being WPA number 339.
And addition of parties,
yes.
Whom do you want as to be added?
We demanded repoll.
Addition of
parties. Petition number Kobita Mahato. Kobita Mahato.
কারা অ্যাড হবে সেটা বলো, যশোর জানতে চাইছে।
Item number 8. Item number 8.
আরে কারা কারা অ্যাড হতে চায় সেটা বলো কোর্টকে।
Kobita Mahato is a contesting candidate of ruling party. We demanded.
Not required, sir. Not required. First, let us hear the legal issue. That you address arguments on the legal issue.
Only, my lord, I'm praying
This
for.
is going to, then for the next 5 years, we will never be able to dispose of this. Yes. All right, all pleadings you complete among yourselves.
My lord, may I?
We will.
I want to file.
Sir, don't keep on dragging on the matter. First, let us finish the contempt.
Your
and then
Lordship.
Yes, thank you.
Your Lordship.
Application may be allowed.
Not required. We will see.
Your Lordship.
My lord, may I just seek one indulgence? My lord, on the 21st, when the contempt is coming up, my lord, I was under the impression, my lord, lordships will hear, my lord, Mr. Raman first. My lord, on whether rule should be issued or not, my lord, in the matter, my lord, or should it be dismissed at the threshold? My lord, I have, my lord, some difficulty on that date, so I kindly accommodate me. I won't take more than 15 minutes on that issue, my lord. Any other.
It is
My lord,
subject to Mr.
yes.
Raman
My lord,
completing, subject to
Your
Mr. Guru
Lordship.
Krishna Kumar completing, then subject to Mr. Raman. You don't know if they will complete.
my lord, in item number 12, my lord.
Yes.
My lord, one affidavit is filed, my lord. We want to give reply of that, my lord. Extended time, my lord.
Sir, your lordship's previous orders is there. Any further affidavits coming in can happen during the course of
hearing.
So, my lord, there's no need, my lord, for all this.
Your Lordship.
In any event, your lordships are going to hear us on the question of law.
Yes, that's it. Yeah.
All that can wait.
So on the question of law only we have to address. So I have only preferred some affidavits.
Not required. Don't bulk the matter. Now you start formulating your points.
Yes.
You say 1, 2, 3. There should not be any repetition. So you, if you are not present, ask a junior to be present, take down, and if one counsel is finished, then the other one. So no duplication, no repetition. So among you all, you hold a conference.
Lordship.
Lord, which is more difficult than anything else.
Your Lordship.
But see, though they may not look eye to eye, issue is everything.
Correct, absolutely.
You approach let it be an issue-based approach. So you have a conference, you convene the meeting, you become the convener.
My lord, in fact, my lord, amongst my lord lawyers in Calcutta High Court, or my lord in Madras High Court, it would be easier than in the Supreme Court. My lord, there they don't even speak to each other.
So that, suppose, let us assume 15 issues are to be argued. Yes. And whoever has got the adequate pleadings on that and material, you take out those issues and argue. Otherwise, it will be a never-ending process.
Yes.
Unless and until you formulate your points and start arguing. You can't just start reading already we have read our orders once, twice, 100 times. In contempt also, we are reading the same orders. So you formulate the legal issue. And very recently, there is one decision of Supreme Court.
Ladakh judgment.
Ladakh
judgment, Lordship, in paragraph number 30.
I'll deal with that.
Yes.
Lordship.
Where the writ is maintainable in certain limited areas of scrutiny. Yes. This is similar to the view expressed by the full bench of the Madras High Court.
Mr. Raman succeeded arguing that.
I know.
So of course, he can't be the doctrine of estoppel will not apply. But let us see how he gets over that.
Your Lordship.
That's it. Thank you.
Your Lordship.
Yes.
In item number 25, we file an affidavit, supplementary affidavit, but
Not
the
required.
opposition which we.
No, you heard us, no? We just said, you formulate your legal points. Somebody will convene a meeting among you, yourselves you discuss which point you are going to argue, and then you make your submissions.
Yes, your Lordship.
Yes.
That's why we want to tell that the opposition which was filed, this did not conflict on the supplementary affidavit which was filed, because the whole legal.
No, not required, sir, not required. Don't worry.
Okay.
Only legal issues, because I appear on behalf of the respondent.
We will commence the hearing, then we'll proceed stage by stage. 25. Thank you. Please call the list.
Serial number 31.
Yes.
Respondent কি ওদিকে যেতে হবে
যা চলে যাবে
Notice to be served on Pollution Control Board.
My lord, item 31.
My lord, at the outset, my lord,
supplementary affidavit.
Yes, my lord, I have prepared.
My lord,
At the outset,
one thing I have to submit.
There was some delay in serving.
But I have got it today, now, this bunch.
In the supplementary affidavit, my lord, I have annexed the earlier writ petition, which was directed to be treated as representation. And there, my lord, it has been the alternative roads have been stated.
Which page? Annexure X1.
Yes, my lord, at page, my lord will find at page, my lord, 16, paragraph 13.
Petitioner states that there are 3 alternate roads through which heavy vehicles can pass via gate number 1, via so-and-so, through riverbed of Balason River. And who will examine the feasibility?
But it was.
I don't even know what is the matter about.
The state has to examine.
State has to examine. The district magistrate who was, my lord, earlier on occasion, my lord, it was directed. Or it has nothing with that, nothing.
They didn't comply.
Yes. The only thing, my lord, your lordship.
Then we'll call for a report from the district magistrate.
As my lord, please.
They have suggested 3 alternate routes. You have got the copy of this supplementary affidavit? Actually, affidavit is 1-page affidavit. Annexures is the writ petition. Have you given her a copy?
It has been given.
Got it.
You
don't have.
Don't
have a senior. Yeah, she's certainly.
No, you show her that page 16.
I'll show.
You just see page 16.
Page 16, paragraph. What they are saying that there are 3 alternative routes, if I got it correctly.
And which is the district magistrate who has to file respond?
District magistrate, my lord, Darjeeling.
Of which district?
District magistrate, Darjeeling.
Darjeeling.
Respondent number 2.
Pursuant to the directions issued on 21.
But I am not required.
No, you please be there.
May I make one
He
submission?
should be there, my lord, to see, my lord, how the.
I'm not on that. May I make one submission? Well, I was served also with your lordship's earlier order, possibly dated 21st of August. Our lordship in paragraph number 2 of your lordship's order has referred to the learned standing council. I am maybe the senior council, but I'm not the standing council. They have their own separate, they have their panel.
You're a senior council.
Yes, but not the standing council.
It will amend.
Could be rectified, my recording.
By order dated 21/8/2023, direction was issued to serve the Pollution Control Board. The notice has been served, and Mr. So-and-so, learned senior counsel, appears for the Pollution Control Board. In terms of the directions issued on 21/8/2023, a supplementary affidavit has been filed. Along with the supplementary affidavit, copy of the writ petition in WPAP number 3 of 2023 has been annexed. In para 13 of the said writ petition, the petitioner has suggested 3 alternate routes through which the heavy vehicles can pass, which are as follows. ABC. In order to ascertain as to whether the three alternate routes which have been suggested can be used for plying of the heavy vehicles, can be examined after a report is filed by the district magistrate of Darjeeling. Therefore, we direct the district magistrate Darjeeling to examine the suggestion made setting out 3 alternative roads through which the heavy vehicles can pass. If necessary, no, not if necessary, the district magistrate shall depute one of his officers to cause a physical inspection of the 3 alternative roads, which are suggested to be the alternative roads through which the heavy vehicles can pass, and based on the report of such inspection, the district magistrate Darjeeling is directed to file a report in the form of an affidavit on the next hearing date. The district magistrate, before filing such a report, shall hold necessary discussion with the police commissioner with the Commissioner of Police, Siliguri Metropolitan Police Commissionerate, who will examine, who will give necessary inputs from the traffic point of view. List the matter on 9th October. Next.
Serial number 32, I'm for the petitioner, man.
Yes.
This public interest is filed against the failure or inaction of part of the forest officers in divisional level or to stop unlicensed sawmills.
Sawmills.
And wood-based industries. What happened, my lord, earlier a division was moved. The division was pleased to pass an order, which at page, my lord, it starts from page 42, my lord. The same petitioner moved.
Good afternoon.
It starts page 42 and opposite parties at page 44 onwards, my lord.
What was the direction issued?
There's a to stop all
Illegal
license, disconnect electricity, seizure of this, all my lord. Pursuant to this order, my lord, they have filed a compliance report. If you also can look at compliance report, I have annexed. This is, my lord, from 46 to 185. Is the compliance what they have said? They have said admitted every this is many of unlicensed sawmills and wood-based industries, and those are, my lord, they have said they closed. This is a 2011 report.
2012-13.
Sorry, 1200. By this time, I've checked out those closed by them. That again started running new. And secondly, my lord, this is they have the secondary units. You also knows it. Though cannot use the round locks. Secondly, they got the secondary units and they are running the sawmill.
In this writ petition,
yes.
Have you listed out at least one or two?
Yes, yes. I will give the list, my lord. You also kindly come to page 186. I give the page 86.
No, this page 186, these are all sawmills which have been closed.
No.
No.
They are not running.
No, these are running according to my lord. It's a huge list. It goes up
I
to
can't get from a North Bengal, and North Bengal are huge one, my lord. Here, I have seen the comparative capital of this list and the comprehensive report. Some are the same who are close at that point of time. They again
once again started.
Unless the seizure of the saw machineries, closure of the electricity dismantles, my lord, it will going on. Second one is another thing very.
But then, Mr. Siddiqui, continuous monitoring is required.
The monitoring is being done because there are, my lord, in terms of Godavarman's judgment, my lord, a wood-based policy has been framed.
Correct.
There is a monitoring, and I have been told, my lord, till February 2023, some sawmills were being run, which were being run illegally, my lord. Around 143 sawmills were closed in different parts of the state till February 2023. But my lord, I have to check it out because these are the sawmills or not, because my learned friend has used an elaborate my lord, list starting from page 186.
South Bengal. Not going, I can't get.
Up to 202.
We are in Jalpaiguri, because there's a many. But secondly, my lord, what I want to place your lordship, if you also can come to page 203 for a moment.
203.
Yes. This is a policy has been framed in parts of the judgment on Supreme Court. The West Bengal, that has not been implemented here.
No, this has been implemented.
No, my instruction has been, if it is implemented.
If the sawmills which have been directed to be closed by the order at page number 40 are once again
long back in 2012.
But how they were permitted to restart their operations without obtaining any permission, etc. It could not have been done. Then it is in contempt.
If these sawmills are operating, my lord, but it has to be checked because this is elaborate list. My learned friend has come up with an elaborate list from starting from 186.
What is
around 143 sawmills, my lord, are not running. This is my specific instructions.
Huge. But there's another thing, my lord, what I'm trying to submit, and they are taking the benefit of they are.
All right, we will direct them.
My lord, paragraph 15, I said, what should be done? If you also can see,
paragraph 15.
If you also can see, what I said that these steps should be taken.
By this public interest litigation, the petitioner has flagged a very important and a sensitive issue with regard to the operation of unlicensed sawmills and wood-based industries in the state of West Bengal. The petitioner had approached this court earlier by filing a writ petition in WP number 882 within bracket W of 2012 for appropriate directions to close the existing unlicensed sawmills and wood-based industries, and also to seize sawing machines of those unlicensed sawmills and wood-based industries, and for other ancillary reliefs. The Honorable Division Bench, by order dated 6/3/2013, had after perusal of the affidavit in opposition filed by the state government, found that certain sawmills are running in illegal manner, and direction was issued to the state government and concerned authorities to take action to disconnect the electricity, and the West Bengal State Electricity Distribution Company Limited was directed to help the state government for closing down the unauthorized sawmill by disconnecting the electricity connection. Further direction was issued that the trade licenses issued to such illegal sawmills should be cancelled forthwith, and no business activity shall be undertaken by the unlicensed sawmills. Accordingly, a direction was issued that to the effect that all the sawmills which are running in illegal manner be closed down within a period of 2 months from the date of the order, namely 6/3/2013. It appears that pursuant to the directions issued, the state government took action and 164 sawmills / wood-based industries were closed down, who were admittedly carrying on illegal operations. The petitioner has come forward with this present writ petition, pointing out that several of those sawmills which were closed pursuant to the orders dated 6/3/2013 have restarted their illegal operations. Apart from that, there are other illegal sawmills which are functioning. And in this regard, a list of unlicensed sawmills in various districts have been annexed to the writ petition. If the sawmills which were unlicensed sawmills which were closed pursuant to the directions issued in the order dated 6/3/2013 have recommenced their operations, it would tantamount to a clear violation of the earlier order, and action has to be initiated not only against the unlicensed sawmill, but also the concerned authorities who have turned a blind eye to such an illegal action, to such an illegality. With regard to the allegation that there are several other unlicensed sawmill operating in various districts, this court would direct a report to be filed by the concerned authority so that the court can examine as to how best the menace can be prevented, full stop. In the light of the above, there will be a direction to the respondents, authorities, to forthwith take action to close down all unlicensed sawmills, some of which has been pointed out by the petitioner in the annexures filed to the writ petition. The authorities concerned are to maintain strict vigil in all the districts where sawmills are operating, and also conduct periodic inspections even with regard to the licensed sawmills.
Yes, no, not licensed, the secondary units. These are
even with regard to the secondary units of the licensed sawmills. Full stop. The petitioner in paragraph 15 of the writ petition has suggested certain actions that can be taken by the concerned respondent, such as seizure of the machinery of the unlicensed sawmills and secondary units and other wood-based industries, confiscation of the seized machinery under the provisions of section 52 of the Indian Forest Act, 1927, read with section 59, capital A of the Indian Forest Act, within bracket West Bengal Amendment, bracket close 1988, permanently dismantling the structures of the unlicensed units, disconnection of the electricity supply, initiation of proceedings under the Indian Forest Act 1927, and West Bengal Forest within bracket establishment and regulation of sawmills and other wood-based industries, bracket close rules 1982, for imposing penalties upon the owners of the unlicensed sawmill, and strict vigilance and surveillance ensuring closure of the unlicensed sawmills, secondary units and other wood-based industries, and non-establishment of new unlicensed sawmills, secondary units and other wood-based industries. We prima facie find the suggestions made by the petitioner could very well be accepted by the authorities, as it would produce the desired result if those suggestions are taken seriously. As observed earlier, strict vigil and surveillance is required, which have to be done by the concerned authorities of the respondents. We would direct the concerned authority of the respondent to file a comprehensive affidavit setting out all the details, and in the meantime, proceed to take action for closing down the unlicensed sawmills, secondary units, and wood-based industries without waiting for any orders in this writ petition, as it is the duty of the respondent authorities to ensure that such illegal activities are not being conducted. We direct the Secretary, Forest Department, State of West Bengal, to form a team of officers under the chairmanship of the Principal Chief Conservator of Forests and formulate a standard operating procedure as to how best the illegality should be prevented. Full stop. Action taken in this regard be filed in the as a report in the
another issue, whether they have implemented the guideline or they can file a affidavit. This is a guideline to the Supreme Court, my lord, at page 203, my lord.
Page
203. And they will, my lord, this is a guideline framed.
Action taken in this regard be filed in the form of a report. Action taken in this regard shall be filed as a report in the form of an affidavit on the next hearing date. In the said report, the concerned authority of the respondent state shall also mention as to whether the notification issued by the Ministry of Environment, Forest and Climate Change, Government of India, dated 11th November 2016, has been implemented. You give a date in November. So we need not wait for an order. That's
that.
next
Lordship is fixing this matter.
November.
November. Yes.
Next.
Serial number 33.
I feel the news service.
Item 33.
My lord, in this matter, I'm for the respondent Howard Municipal Corporation, my lord. If my lord kindly consider the petition, my lord.
What is the representation they have given?
My lord, it is not a mass petition, my lord. So appeal doesn't lie, my lord. First of all, my lord, that is my first submission, my lord. And if my lord kindly
unauthorized
my lord,
illegal
it is a
groundless
file matter,
file
municipality matter, my lord.
may be collapsed at any moment. life of 1,000 persons of the locality in a very crowded residential area. In which your district? Howrah.
My lord.
You can cause an inspection of the building.
Yes, my lord. I can file a report in the
By
form of
this
affidavit.
petition, the petitioner seeks for consideration of the
But there's no
his
petitioner. My
representations.
petition is not present before lordship. I am for the
Yes, yes, by representation
filing report on
dated
behalf of
10/8/2023. What is that?
a copy.
And
No.
18/8/2023, wherein it has been alleged that illegal and unauthorized construction has been put up in premises number 41/1, Viprodas Chatterjee Lane, Police Station Shibpur, District Howrah, under the Howrah Municipal Corporation, Ward number 34, without obtaining any sanction plan from the Howrah Municipal Corporation. Since the representations were not considered, the petitioner has filed this writ petition. The inspector in charge, Shibur Police Station, has filed a report dated 8/9/2023, in which it has been stated that during inquiry, it is revealed that an old G+3 storied building is situated in the said premises, and one shed has been erected on the roof of the said old building, and the construction being an illegal construction, the same has been communicated to the Assistant Engineer, Building Department of Howrah Municipal Corporation, and also to the Assistant Engineer, Borough 5, Roman 5, Howrah Municipal Corporation, wide communication dated 25/7/2023. Further, the police authorities have also communicated about the illegal construction again on 5/9/2023. It appears that till date, no action has been initiated by considering the representation of the petitioner, nor action appears to have been taken by the Howrah Municipal Corporation pursuant to the reports filed by the inspector in charge, Shibur Police Station. Since the writ petition is being disposed of without calling for affidavits, we do not express any opinion on the merits of the allegations made by the petitioner. However, it goes without saying that in the event there is an illegal or unauthorized construction, the Howrah Municipal Corporation is duty bound to take appropriate action upon notice to the said persons who have put up illegal or unauthorized construction without waiting for any direction from this court. Therefore, we direct the
Respond 2 and 3.
Second respondent to consider the petitioner's representation, issue notice to the 8th respondent, on 8th and 9th respondent and all other concerned, cause an inspection of the building, and in the event, if it is found that the construction is either illegal or unauthorized, or the building is in a dilapidated condition, appropriate action be initiated under the relevant statute after hearing the agreed persons. This direction be complied with within a period of 8 weeks from the date of receipt of the server copy of this order. Next.
Real number 34.
Yes.
34, my lord, I am appearing on behalf of the petitioner, my lord. My lord, I have served.
Who appears for the Southeastern Railway?
Yes, my lord. I have served upon all responded. They have duly received, my lord.
You want a halt between two stations?
Yes, my lord.
What is the distance between those two stations?
Two stations, my lord, more or less 6 kilometers.
6 kilometers is very difficult.
My lord,
unless
they have considered, my lord,
they have
after
considered.
filing the writ petition.
Oh, that's nice. Because yes, madam. If it is a suburban train, they will do it.
Yes, my lord.
It's an
Only
express train or
dispute,
a passenger.
only, my lord, the dispute is name. The station falls under the Kesra Moja, but the railway authorities has given the name Karjuidanga instead of Kesra. My lord, now the problem is solved, my lord. The Divisional Railway Commissioner issued a notice to the block development officer that, my lord, subject. May I read, my lord?
Yes.
Naming of passenger hall of Karjuidanga between Bankura and Achuri as over Kesra Karjuidanga Hall Station, Adra Division. Now the station name is Kesra Karjuidanga instead of only Karjuidanga.
Doesn't matter.
Yes, my lord. Matter, kindly record this memo and pass this order.
We have heard the learned advocate for the petitioner. The petitioner had filed this writ petition, praying for a direction upon the respondent authorities, in particular the second respondent, to name the newly constructed halt station in between Anchuri and Bankura station at Keshara as Keshara
Karjuidanga
halt station instead of Kajuranga. So it is there in this prayer, page 8, instead of so and so. The learned advocate for the petitioner submitted that the grievance expressed by the writ petitioner has been resolved in the light of the decision taken by the railway board, and the same has been communicated to the block development officer, block 2, Bankura 2, by the assistant commercial manager, Adra division, Southeastern Railway, by a communication dated 29/8/2023, wherein it has been stated that further process is being taken for issuing commercial notification to correct the spelling of the name of the proposed passenger halt. In which the name of the halt station has been made as
Kesra Karjuidanga, my lord.
Thus, in the light of the decision taken by the railways, the grievance which was projected by the petitioner in this writ petition has been redressed. Thus, by recording the stand taken by the respondent railway administration, the writ petition stands disposed of.
Grateful, my lord.
Next.
Serial number 35.
My lord, if you were the state respondents, your lordship.
Yes.
Yes, ma'am. Well, the land in Salt Lake was allotted under the government Grants Act 1895. And my lord knows better that the terms of the grants has overriding effect on any other law inconsistent therewith. And my lord, the first case in this matter, there are so many cases are there. In famous one is this Haji versus State of Tamil Nadu, wherein Supreme Court said that even the equity is not applicable in a government Grants Act. The land in Salt Lake and this was given part of for residential purpose, having no roof on the head of the very cheap rate, and another for industrial purpose. Well, like in Sector 5, in Salt Lake, there are many plots given by, I know the background, 30,000, 40,000 price per total plot of land, not even kathas, for establishment of the industry there. Now, this notification is being done surreptitiously because, there is an act, there is a law. So, therefore, one has to make a subordinate legislation, circular, and that has to be, even a circular is a law under Article 13, my lord, there is even a circular notice and notification. So, this notification is done, issued to legalize illegal development agreement. What happened? Many plot holder they entered into an illegal development agreement with some promoters. And there are crores of rupees involved in this deal, because unless the authority is being bribed by the how could this such circular, can we have a look at the circular? It has come to the notice of the government in the UD department that a number of lessee of non-resident land of Salt Lake entered into a development agreement with the developers by transferring proportional share of the leasehold right of the land built up space of building with proportionate share of land with or without prior permission of the government. Admitted fact that the government has not permission. As per settled proposition of law, if the land is granted under the Government's Grants Act, it's like land revenue, like land acquisition act, straight away, and the terms of the grant also, one can straight away re-enter into the position. In a government grants, no TP Act is not. There was a case before the Honorable Appeal State whether transfer of property act will have whether one has to file a suit or not. Honorable Supreme Court held no suit is required to be filed. State oil like land acquisition is a special act. Therefore, if government finds that there is an illegality, there is an illegal for profiteering, so government should straight away will give a notice. That is also written in the terms of the grant. Notice and take back the possession. So what they have done, the matter realizing of the transfer fee of the cases, well, this notification is contrary to the statutory provisions. So if a, my lord, if a subordinate legislation or notification is contrary to the Parent Act, that is a void.
And page 24, there is some interim order has been granted. Page 24. What is that?
Page
24, annexure P2.
That is. No, my lord, that is, there was the, I tell you one thing, there was very unholy alliance between the officers and the office. This case was whether government can impose tax under Article 265 of the code, whether the fees is quid pro quo. Fees is also a tax. Whether without a legislation, government can impose tax on that was issued, but surreptitiously there was an agreement, an appeal was filed. I was
now the petitioner's case is that no transfer can take place.
Yes.
Now, by virtue of this notification, they are regularizing the illegal transfer.
They're trying to regulate because there was an act. Because this is our legislation. My lord knows the Lokprahari versus state of UP, the allotment of plot. There is an honorable officer case. If a notification is contrary to the statutory provision, that is a void. And more so much, this is for the industrial purpose. The land is allotted for the industrial purpose. And my lord knows better the AP Development Dairy Corporation, government is a continuing body. Unless the policy of the previous government is contrary to law, that policy will remain. Another part.
So, whether the non-residential plot, my lord, has it been converted into a residential plot?
Well, that is no. That is that's the way. My lord knows MC method starting from MC unless the change of user is being amended in the amendment plan or development plan, no conversion can be done. But in another matter, pending before this court, this honorable court direct the government to produce the document that you have converted this land.
Now, where is the division bench direction?
No, my lord, this division bench direct, this is, in fact, they have withdrawn the case. Because government mutated their body in the division bench, after this judgment, they withdraw the case. That is a different case, man. That is a different case. That is a different case. I showed this case to show how this has been this is going on here. This order I placed just because.
So these people entered into a lease agreement with the government for putting up an industry. And it was given at a very, very cheap rate.
40,000. 50,000.
And now they have entered into a development agreement.
They have surreptitiously entered into a development agreement for residential and other purpose in an industrial area.
And the procedure, my lord,
Yes, what is your
another thing, my
I
lord,
say one thing only, your lordship.
another part. My lord, 2005, a notification was issued on the same data. That has not been superseded even. And that in that notification, government specified, first of all, my lord knows better that executive instruction under 166 there should be a cabinet decision or there is a law. Because if there is a law, that is not possible. Kindly see this notification on the same subject.
And what does this notification?
That is, you can convert, you can change for industrial purpose. Actually, I'm reading out my 2005. It has come to the notice of the government of West Bengal that quite a good number of industrial plots in Sector 5 and commercial plots in Sector 5 and outside Sector 5 of Vidhannagar are lying unauthorized and unutilized even after the delivery of possession of the said plots to the lessee were made long ago. It has also come to the notice of the government that a good number of such industrial and commercial plots with industrial commercial units are lying unused in Sector 5, etc. While examining the recent, well, page, first para, that is there.
Oh,
What this is the one that is there. Oh, sorry. This is true. Yeah.
No, it's not there. So Sector 5 is not here.
Yeah, it is Sector 5, my lord.
No, which paragraph you are reading?
I am reading paragraph 1 to starting from 1.
No, it says it has come to the notice of the government of West Bengal. Quite a good number of industrial commercial plots with so and so units in Vidhannagar are still lying unutilized. All those.
But Vidhannagar Sector 5 is Vidhannagar. So Sector 5 is
you read as Sector 5. There is no. Sector
no.
In Sector 5. All right.
And in order to paragraph 3 to scholar, in order to streamline the entire process and to ensure that all unutilized plots of industry and commercial land and industrial with the Vidhannagar as put to effective use in all manner, the governor has been pleased in terms of section 2/8 and clause 2/6A of the lease deed or the relevant clause of the lease deed, restricting transfer to other than the government of West Bengal shall allow the lessee of Vidhannagar industrial commercial plot, etc., with industrial commercial unit to outright transfer the leasehold right of his or her industrial commercial land and industrial commercial land with industrial commercial unit, either partly or wholly, to other for the unexpired period of the lease term subject to certain conditions laid down herein below. The governor has further pleased to order that for the aforesaid purpose, the words, the lessee shall mean proprietor, partners, private limited company, public limited company, proprietors, etc. To seek the permission of the government to transfer the leasehold right to other, the lessee shall have to apply to the principal secretary to the government of West Bengal, such and such address, specifying the reasons for such transfer. The transfer of the above leasehold right to the close blood relation will, however, continue to be governed by the order which is already in force. The governor is also pleased to order that if such permission is granted by the government of West Bengal in the UD department for transfer of the leasehold right to the other by the lessee of the aforementioned plot, all terms and conditions of the original lease deed exist.
No, I think you can come to para 5.
Yes.
Para 5.
Para 5 important.
Para 5 says the character of the land, industrial, commercial, shall have to be retained by the transferee of the.
Yeah, well, that is the civil settled proposition of law.
All right. Now, this notification has not been superseded.
No.
And by virtue of this notification, this has virtually become a dead letter.
May I just indicate one thing, Your Lordship? May I just come back with affidavit in opposition?
Yes, you have to do that.
I have to do because
It's a
I have
very
to
serious
disclose.
matter. See,
I understand.
in this page 60 notification, it says, first paragraph, last third line or second line, they entered into development agreement with developers by transferring proportionate share of leasehold right of land, built up spaces of the building with proportionate share of land with or without permission of the government. So now you are regularizing an illegality.
That more so, my lord, it is a settled proposition of law starting with MC Mehta's case. The no earliest amendment of the development plan, we cannot do that. Even the town and country.
No, under the Town and Country Planning Act, change of user is permissible.
Permissible.
But for which elaborate procedure is there, including public notice.
But another judgment is here that West Bengal Town and Country Planning Act is not applicable to the Salt Lake. But that order has not been challenged. Therefore, the terms of the grant, in Tata State, Haji versus State of Tamil Nadu and other Indian Express, the terms of the grant is overriding effect. In fact, before the constitution came into force,
any sample lease deed is there?
Pardon?
Sample lease deed.
Yes, I annexed on
page.
Page, my lord. My lord, page 34. Page annexer P7, page 49, sorry, page 49. This is for residential purpose, but the lease deed is almost same.
The lessee shall not subdivide, sublet the demised land or the building to be constructed without the consent in writing of the government. Had to be obtained and shall have a right to, or not assign, transfer the demised land to any part of so and so without previous permission of the government.
Kindly section 4, kindly see section 4. Provided if there be any breach of any of the terms and condition and covenant herein on the part of the lessee contained, the lessor shall have the right to re-enter into possession.
Which clause?
Clause 4. Clause 4. Last page, page 55. Haji versus State of UP. Haji no, Haji Mani.
Sir, please take down. You please file your affidavit.
My lord, this is the judgment is Azim versus State of UP here in Supreme Court held that
the copy the number.
But country start from paragraph 27 onwards. Paragraph 27. For taking possession of the state government is required to follow the law if any prescribed. In the absence of any specific law, the state government may take possession by filing a suit. Under the provision of Land Acquisition Act 1894, the state government decides to acquire the property in accordance with the provisions of the said act. No separate proceedings have to be taken for getting possession of the land. It may even invoke the urgency provision contained in section 17 of the said act
and the collector may take possession of the land immediately after the publication of the notice under section 9. In such a case, the person in possession of the land acquired would be dispossessed forthwith. However, if the government proceeds under the terms of the Government Grants Act, then what procedure to be followed? Section 3 of the Government Grants Act stipulate the lease made by or on behalf of the government is to take effect according to their tenure. All provisions, restrictions, conditions, and limitation contained in any such creation, conferred or grant referred to in section 2 shall be valid and take effect according to their tenure. Any decree or direction of a court of law or any rule of law, statute, or enactment of the legislature to the contrary. Now, the last paragraph, the residual.
Now, this lease deed is under the Government Grants Act?
Yes. My lord, this is Haji versus State of Tamil Nadu. The Honorable Appellate Court said that there is a dispute of license in Tamil Nadu. Extra. Hey. X seconds. In para 12, on Haji versus State of Tamil Nadu. Can you see? Start from paragraph 9. Paragraph 9. Section 2 of the Government Grants Act insulates all grants and all transfer of land or any interest therein made by the government from checks of the provision of TP Act. Section 3 of the Grants Act protects the terms of such grant from the provisions of any other law. We extract the above two. TP Act is not applicable. Grants Act applicable. Para 10. The combined effect of the two sections of the Grants Act is that terms of any grant or terms of any transfer of land made by government would stand insulated from the tentacles of any statutory law. Section 3 places the terms of such grant beyond the reach of any restrictive provision contained in any other enacted law or even the equitable principles of justice, equity, and good conscience adumbrated by common law, if such principles are inconsistent with such terms. The two provisions are so framed as to confer unfettered discretion on the government to enforce any condition or limitation or restriction in all types of grant made by the government to any person. In other words, the right, privileges, and obligation of any grantee of the government will be completely regulated by the terms of the grant.
Correct. This is a settled position.
An attempt was made to show the transaction was evidenced by this agreement, not a grant but a lease of land. Though it is now not open to the appellant to raise such a contention, clear finding, etc., that it was not a lease but only a license coupled with the interest, which finding were not challenged, etc. Assuming that it was a lease of land, still the appellant cannot succeed because lease made by the government is also covered by the protection in under Section 2(3) Act.
Because it is been termed as a lease because actual physical possession has been handed over.
But title
the distinction, 67 Supreme Court, a distinction between a lease and a license.
Right.
So even if it is considered to be a lease, still it has got conditions. Those conditions cannot be violated unilaterally without the prior permission of the grantee.
My lord, there was a case in.
I'm sorry, grantor.
But there was a
the grantee cannot.
Justice 1954 Bhatia versus State. Justice Vivian Richard said there was now a misconception.
We will grant some order. We have heard so and so. In this writ petition filed as a public interest litigation, the petitioner has challenged the validity of a notification issued by the Government of West Bengal Department of Urban Development and Municipal Affairs dated 28th April 2023. This notification provides for a levy of a permission fee to be charged by the government in cases where the lessees of non-residential land of Salt Lake entered into development agreement with developers by transferring proportionate share of leasehold right of land / built up spaces of the building with proportionate share of land with or without permission of the government. With or without permission of government, you please highlight. And within bracket, emphasis supply, bracket close. Full stop. The petitioner would contend that the notification is illegal and is illegal and ultra vires the provisions of the West Bengal Government Land within bracket Regulation and Transfer Act, Regulation and Transfer bracket close Act 1993, as well as Article 265 and Article 14 of the Constitution of India and the provisions of the Government Grants Act 1895. Apart from being contrary to the scheme and policy decision of the government to allow industries in the state for generating employment in Salt Lake and in other parts of the state of West Bengal. A sample lease deed has been annexed to the stay petition, from which we find that the lessee, lessor is the state of West Bengal, and the lessee is not entitled to subdivide or sublet the land or the building to be constructed without the consent in writing of the government, which has to be first obtained. And the government has a right to refuse its consent at its absolute discretion. Further, there is a clear embargo on the lessee not to assign or transfer the land or any part of the land or structure erected thereon without the previous permission of the government in writing. The lease deed also clearly states that if there is any breach of any of the terms and conditions and covenants on the part of the lessee, the lessor, namely the Government of West Bengal, shall have the right to re-enter into possession of the land or any part thereof. Any part thereof. If such is the nature of grant, the question would be as to whether the impugned notification dated 28th April 2023 can supersede the terms and conditions of lease, which prima facie appears to be a grant, and if it is so, will be covered by the provisions of the Government Grants Act 1895. Curiously, the impugned notification dated 28th April 2023 not only speaks of transfers with the permission of the government, but also with regard to transfers which have been done without the permission of the government. This, in our primary view, would grant a seal of approval to an illegality, more particularly when the grant had a specific condition that without the prior permission of the government, no transfer or even construction can be put up in the land in question. On 6th May 2005, the Government of West Bengal, Urban Development Department had issued a notification published in the Kolkata Gazette dated May 20, 2005. This notification came to be issued taking note of the fact that several industrial/commercial plots and industrial/commercial plots with industrial/commercial units in Bidhanagar are lying vacant, unutilized, although the lessees had taken delivery of possession of such plots from the government long ago. Therefore, the government issued certain directions, and at this juncture, it is relevant to note that in terms of paragraph 5 of the notification dated 6th May 2005, the character of the land within bracket industrial/commercial bracket close shall have to be retained by the transferee of the leasehold right. Thus, if such was the full stop. It is the case of the writ petitioner that the notification dated 6th May 2005 has not been rescinded or superseded. If such is the position, can the government now issue the impugned notification dated 28th April 2023 by virtually granting a seal of approval to illegal transfers of non-residential land in Salt Lake to be utilized for residential or other commercial purposes. The petitioner would also state that these lands were allotted to various allottees/lessees with the object of promoting industrial growth in the state, thereby generating employment. And by virtue of the impugned notification dated 28th April 2022, the said object has been defeated. The learned advocate for the petitioner placed reliance on the decision of the Honorable Supreme Court in the case of Haji SVM Muhammad Jamaluddin Brothers and Company versus Government of Tamil Nadu, 1997, 3 SEC 466, for the proposition as to the combined effect of Section 2 and 3 of the Government Grants Act. Reliance was also placed on the decision of the Honorable Supreme Court in Azim Muhammad Kazmi and others versus State of Uttar Pradesh and others, 2012, 7 SEC 278. As to the effect of the conditions which are imposed by the government while making a grant under the provisions of Government Grants Act 1895, with particular reference to Section 2 and 3 of the said Act. Thus, we are prima facie satisfied that the impugned notification dated 28th April 2023 in effect perpetuates an illegality which would be against public interest. For the above reasons, the impugned notification issued by the Government of West Bengal, Department of Urban Development and Municipal Affairs dated 28th April 2023 shall remain stayed till the disposal of the writ petition. The respondents are directed to file their affidavits within a period of 6 weeks from date, reply if any within 3 weeks thereafter, list the matter on so and so date, give a date after that. We make it clear that the above observations are prima facie observations in aid and support of our conclusion, in aid and support of the court coming to the conclusion that court taking a prima facie view that the impugned notification is illegal, warranting grant of an order of interim stay.
Only thing, my lord, Azim's case, you could say no suit, straight away government can take the position.
We just for the prime facie, let him file his affidavit. Next.
Serial number 36.
My lord, I am for the petitioner. Yes, my lord. My lord, both the petitioners are residents of that area, my lord. One in 2005.
What do they want?
My lord, in 2005, for a specific purpose, so a plot of land was gifted to the Gram Panchayat, Mohanpur Gram Panchayat, for establishing a field so that the resident of that area can play, since there is no playground. And for the cultural purposes. My lord, now Gram Panchayat in 2014, they started selling that property. Though the purpose of gift to the Gram Panchayat is specific, but they are selling that property, my lord.
This is an out and out land dispute. Kindly sees, my lord, the paragraph 10. In connection with the said lands, few civil proceedings have been initiated. In other words, civil suits have been filed. In the same breath, kindly see my prayer B at page 9, my lord, seeking for a declaration that all the sale deeds be declared void. In
But
this,
if suppose a land has been reserved for a public purpose, like a children's playground, park, or for some recreational purpose, any transfer is void, not voidable.
no, that my lord, but from the red petition, I find that they are saying that
This
there
transfer,
was a gift,
see,
gifted land.
page 29 is a deed of exchange.
Yes, my lord,
What is
and
that?
page deed of exchange is deed of exchange is the Gram Panchayat sell the property to a private respondent.
Where is the
And,
original grant?
Original is, my lord, kindly came to page number 13 onwards, and specific is 19. 13 is the, my lord,
Document.
yes, my lord, and page 19 it is specifically mentioned. May I read, my lord? Though it is scripted in Bengali, my lord.
Lordship will, you read. Lordship will.
এখানে may I, my lord?
Yes, yes, please.
My lord, এখানে আমরা আমাদের উপরিদিক্ত সম্পত্তি সমূহ বিলি বন্টন বন্দোবস্তকরণের উদ্দেশ্যে দান বিক্রয়াদি করিতে প্রবৃত্তি হইয়াছি। আপনি গ্রহীতা অবগত আছে যে উপরোক্ত সম্পত্তি আপনার পঞ্চায়েত এলাকাধীন এবং এই সংসদ এলাকায় ক্রিয়া শরীরচর্চা বা সংস্কৃত চর্চার জন্য কোনো উন্মুক্ত মাঠ নাই। এ কারণে আমরা ওয়্যারলেস পাড়াবাসী সহ জনস্বার্থে ক্রিয়া প্রশিক্ষণ শরীরচর্চা সংস্কৃত চর্চা কেন্দ্র স্থাপনের নিমিত্তে উপরোক্ত then my lord specification of the lands, then my lord come my lord.
This is a gift deed.
Yes, my lord.
Executed by a private person in favor of the panchayat.
Yes, my lord.
Whether the gift was accepted by the
Yes, my lord. Panchayat is accepted the gift in 2005, my lord. This is the registered deed, my lord.
That
My
is
lord, kindly came page number 14, my lord. Grohita is Mohanpur Gram Panchayat.
Now, who has executed this deed of exchange?
Gram Panchayat represented by Pradhan. Man, that is, my lord, page number 27, my lord. Seven onwards.
It is a land which has been gifted. How did the registration, sub-registrar accept registration of a deed of exchange?
May I, my lord, suggest one? My lord, there is a representation I find made at page 68 to the DM of the district, my lord. May it be sent.
No, he has to inquire into it.
Lordship. And the director, my lord,
And my
just
lord,
came here to
kindly
inquire
ask for a
into it.
report so that my lord can peruse the.
Let him decide, my lord.
No, see, now that the construction has already started, there may be several private parties.
Well, only
Or-
three. My lord, two deed is
Private
executed.
party has not been served.
Yes, my lord, it is served, my lord. Private respondent numbers
For
5,
the-
6,
for
7.
the
my lord.
present, we will direct the district magistrate to inquire into it. We'll make an observation if the land has been gifted, meant for a public purpose, accepted by the panchayat, then the panchayat becomes the trustee of the land.
Yes,
It can't trust. Any decision you have
Yes.
got?
Yes, my lord.
Are you carrying any decision with you? No, you didn't do your homework.
No, my lord, my
There
lord.
are several decisions which say that once a land is earmarked for a public purpose, let us assume there is a housing layout being prepared. There are statutory conditions, like if there are 1,000 plots, you have to provide for a playground, shop. So if it is 10,000 plots, even for a police station, land for a police station, which will be given to the department and the department will purchase it. But certain areas like playground, children's playground, etc., roads, they all vest with the panchayat, municipality, etc. They have to maintain it as it is without any change of user. There are several decisions.
Yes, my lord.
One decision is Pandit Chetram, PT. Pandit is PT Chetram. You Google and find it. By this writ petition, styled as a public interest litigation, the petitioner seeks for appropriate direction upon the respondents to declare all transfers by way of sale or exchange of a land which has been earmarked for a public purpose in favor of third parties as illegal and void. In the year 2005, an extent of a plot of land was gifted in favor of the panchayat by one Mr. Ghosh, correct?
No, my lord, there are several person, my lord. One Nimai Ghosh.
By
Second
70%.
is, yes, my lord.
And the gift is said to have been accepted, and the panchayat had earmarked the land as a playground/play area. The allegation in this writ petition, as well as in the mass petition dated 6th August, 6th August 2020. No, 8th May. What? 8th May 2020.
No, 8th May 2023.
2023 is that the Pradhan of the Panchayat, who is the which respondent?
The Jela Shash.
Pradhan, my lord.
Fourth respondent.
Respondent number 4. Yes,
has executed a deed of exchange in favor of the private respondents 5 to 7 by transferring the land in their favor for private gain. Though the private respondents have been served and affidavit of service has been filed till date, so none appears, none appears for the private respondent.
Lordship, I am representing only 1 and 2, my lord. I cannot, my lord, Jila Parishad or lordship.
The fourth respondent is also not represented. The third and fourth respondents, those served, are also not represented by council. We have heard the learned government council for the respondents 1 and 2. The legal position, which has been settled in various decisions, is that if a land has been earmarked for a public purpose, the same has to be preserved as such, and the panchayat or the municipality to whom the land has been entrusted has to preserve the same without any change of the character of the land or the purpose for which the land had been earmarked. In the event, if any transfers had taken place, the transfers are all void transactions and no right will accrue in favor of the transferee, as such transfers are illegal. In this writ petition, the petitioner alleges that the fourth respondent has transferred the land gifted for a public purpose in favor of the private respondents. In this regard, a mass petition has been given to the district magistrate on 8th of May 2023, and the same is pending consideration. In the light of the above, there will be a direction to the second respondent, namely the district magistrate North 24 Parganas, to consider the representation dated 8/5/2023, direct the third and fourth respondent to place all the records pertaining to the land in question, direct one of the officers of one of his officers to conduct a spot inspection of the plot of the land in question, and thereafter, if it is found that the transfers are illegal, appropriate action be taken in accordance with law. Full stop. It goes without saying that the respondents 5 to 7 have to be put on notice prior to taking any action, and the views of the writ petitioner or other representatives in the locality shall also be ascertained before final orders are passed. The above direction be complied with within a period of 3 weeks.
4 weeks.
4 weeks from the date of original owners.
My lord,
within a period of 4 weeks from the date of receipt of the server copy of this order. Before that, the district magistrate, before taking a decision, shall also issue notice to the donors who had executed the gift deed dated
20 July 2005.
No, Deed gift is 20th
2nd
June
June.
2005.
2000 June.
June 2005.
2nd June 2000. Next.
20 June.
Serial number 37.
My lord, meanwhile, they have started
Meanwhile,
construction, my lord.
All right. Next. Probably your client also wanted to purchase.
No, my lord.
Could be.
My lord, they are, my lord, the committee.
They will file a review petition and come.
Yes, my lord. My lord, affidavit of service, my lord, kept on record, my
Kept
lord.
on record. Next.
Grateful, my
Mandamus to
lord.
direct
I'm for the-
illegal unauthorized construction.
I'm for the state. But the petitioner alleges the illegal unauthorized construction, huge unauthorized construction.
And what is the land? It's a water body. Is it?
It's a water body.
And where is the document to show it's a water body?
No, my lord,
Where for the state?
state
I'm
can-
giving the report. There is no illegal construction has yet been made.
You could have disposed of his
The
representation.
Panchayat authority is the competent authority who shall take into consideration the.
Let us see this report. If you want extra copy is there, you please give. This is by the sub-inspector.
This is a police report.
Police report. So puja purpose, they want to put up some pandal. That is all right. You see the
Yes.
photograph, color photograph.
Photograph, there is no mandir or like that.
The petitioner, by way of this writ petition, alleges that the 11th respondent is putting up an illegal and massive building in the plot, in the land comprised in LR plot number 1954 of Mauza, Mobarpu, LR Kaitan number 2511, JL number 201, under police station Memari district, Purva Bardhaman. According to the petitioner, that the land, the construction which is being put up is illegal and wholly unauthorized and has to be immediately stopped. The officer in charge of Memari police station has filed a report dated 11/9/2023 stating that as on date, there is no semblance of any construction and there is only a small room. However, at the time of Kali Puja and Saraswati Puja, the neighboring the people who are residing people of the locality erect a pandal, and after the puja festival is over, the pandal is dismantled and no permanent structure has been put up. In the light of the said report, though at present there may not be any construction being put up, the seventh respondent, namely the block development officer, Memari 1 block, post of so and so, is directed to conduct a spot inspection of the area, and if the land and ensure that no illegal or unauthorized construction is put up on the said property. With the above observation, writ petition disposed of.
Next, in state of respondent number 7, it should be respondent number 6, the subdivisional officer. As per the Panchayat Act, subdivisional officer is the authority to look into this matter.
Sixth respondent. Oh, not 7th, 6th respondent.
Your allegation is that construction without plan.
Without plan.
SDO will look into this matter.
The Panchayat authority will take a decision whether the building is illegal or not. Then he has to send the matter to the SDO. SDO then have to consider according to section 25.
Sanction the Panchayat will grant.
Panchayat will grant, but
that is your allegation, construction without
legally.
Let it remain like that. Next.
Every service may be kept in the record.
Next.
Serial number 38.
Well, I am the landowner. I have not been made party, although it has been stated
private respondents are doing all these things. We are
But
the
here-
private, I have not been made party. But the busybody has come up, my lord, without any evidence to show that there is a water line.
Your Lordship,
Not a
let
single
them
annexure.
show that there is a sanction plan because in 5 acres of land, construction is being done, which has now reached a 4-storied building. And in spite of letters written by us, no stop work notice was issued by the KMC, Your
See
Lordship.
the annexures, my lord, lawyer's notice.
May I beg to appear for the
Address-
state respondent, Lordship.
Address has been given of full
Let them
post office
first
street.
satisfy whether they have a sanction or not.
Who's putting up illegal construction?
Your Lordship,
In the legal notice also, you have not informed them.
Your Lordship, we did not know the name of the promoter, but construction, we went to that site to buy a property, Your Lordship, and we
You
came.
are not able to buy the property, therefore you.
Your Lordship,
Yes,
not
yes.
that I'm
That
not
is
able
exactly
to
the
buy that property. Let them show,
Price is not
now
shown.
that they are there,
You make a proper
Your Lordship,
representation.
I'll
they
make
will-
them. Leave may be granted to add them as a party, Your Lordship.
No, no,
By this
Because-
writ petition, the petitioner alleges
no evidence of water land.
This is staff of the advocate's office.
Ah,
Bolo na.
advocate's office.
by this writ petition styled as a public interest litigation, the petitioner, who was desirous of booking a flat in a building being constructed at premises number 23, Topazio Road, Kolkata, 39, visited the site in question and made enquiries and learnt that a building is being constructed at the site in question without obtaining sanction plan. In the writ petition, a copy of a legal notice sent to the various authorities has been annexed. Apart from that, there is no other document placed by the petitioner to show as to in what manner the construction, the alleged construction is illegal and who is putting up the said construction. In any event, from the averment set out in paragraph 4 of the writ petition, it is seen that there is a semblance of a private interest of the petitioner involved in the matter, and therefore we find no grounds to entertain this writ petition as a public interest litigation. Dismissed. Next. Next.
Serial number 39.
Lord, I appear for the respondent number 8.
8. Very good.
But my lord, I have got a preliminary objection, my lord. The Moistella municipality against whom one of the main allegations is they have not been made a party. The chairman Moistella municipality has been made a party. Only without the Moistella municipality itself being made a party.
No, they want to ensure the open the gate of the children's park. Who closed the gate?
There was an earlier writ petition filed by the writ petitioner, in which there was an order passed by a court bench of this court, in which it was stated that in the event the state government or the municipality intended to change the nature and character of the land, then it had to do it in accordance with law. It appears
Yes, you are first.
in that event.
And what is your report? Any report is available?
Yes, please, my lord, today, my lord, I appear for the chairman, Moistella municipality, who has been entrusted with the work of upkeep of the property and the execution of the property project. Now, my lord, we have received copies from the government of West Bengal, in which the land was, the nature of the land was changed into classification from playground to a community hall. The LR report, LR Porcha, the latest LR Porcha, which my Lord Junior will hand it over to your lordships, clearly shows, my lord, that it was changed.
Who's for the writ petitioner?
I'm for the petitioner.
What is your case?
My lord, the respondent authorities are trying to change the nature and character of the said plot.
But there has been earlier writ petition, page 28.
Yes, my lord.
And same allegation.
Yes, my lord.
I
Kindly.
appear for the state. Namala, I have all instruction in writing also. There are some documents also. I can place before your lordship. But before that, if your lordship kindly, yes, my lord, very rightly, my lord observed that there was an earlier order On the basis of that, my lord, the entire thing, my lord, the after all, my lord, the subsequent development. My lord, kindly come to my lord, internal page number 41, the running page. That is the internal page 14 of the my lord, the order or the judgment, the whereby the earlier writ petition was disposed of. My lord, kindly come to page 41, paragraph number 20.
Yes.
Paragraph number 20. Applying such proposition of law to the facts of the instant case, we are of the opinion that the nature and character of the plot being LOP number such and such, which stands recorded as a children's park in the layout map of the Refugee Relief and Rehabilitation Department of the Government of West Bengal, cannot be altered, and no permission can be granted for construction of a community hall upon the said plot without alteration of classification of the plot in strict consonance with the statutory provision. So, my lord, there was then, my lord, there was a scope giving that if the entire process or entire thing is being done in terms of the provisions of the law, then it can be done whatever be there that in the layout plan, because the policy was that there should be a community hall for the entire region, entire area. Now, lordship, kindly come to this, my lord. There are some documents after this judgment. Just, my lord, a few of these, lordship, kindly come to, my lord. Sorry, my lord. My lord, kindly, my lord, the first page is, my lord, that is, my lord, the LR and the Block Land Reform Department, he, my lord, addressed to the additional district magistrate with regard to inquiry report after this, that the inquiry was done. Then, lordship, kindly come to the next page of 11 July 2022. This is, my lord, from the Secretary of LR Department, RR Department, Refugee Department, from the then, my lord, district magistrate is written there that, my lord, the second paragraph. Now, BL and LRO had submitted a proposal for rectification of plot number in the sanction order. He has proposed that the plot number is actually this and this. Hence, a corrigendum for the sanction order may kindly be issued. Again, for your kind information, BL and LRO Behala has sent a copy of judgment. This is the judgment. These are the, my lord, the steps taken. Then, my lord, the next page, the page number 3. This is, my lord, a memo, my lord, issued by Deputy Secretary Government of West Bengal to the District Magistrate and Collector of South 24 Pargana. My lord, kindly come to, my lord, the contents. In sending here with a copy of the memo under reference along with its enclosure, undersigned directed to request to change the classification of LR plot such and such as community hall in place of children's park in pursuance of the order of the Honorable High Court. Steps taken. Then, my lord, the next page. Please,
we have not received any of these copies.
I shall give. I shall hand over.
You have to challenge this.
I shall hand over.
In that case, Lord, I have to challenge. What does
My lord, just, my lord, the next.
nothing
But it is a motion stage. It's a motion stage.
No, it has happened very recently. But one mischief they have done here, sir. You come to page 4, 28th of June, 2023. You see subpara 3. Then change the classification of the Batta plot.
Yes.
Batta plot so created a so and so as community hall in the place of children park.
Yes.
To comply with the director of the High Court, Calcutta. Where is the direction?
The language, my lord, lordship, my lord knows, my lord, the language, my lord, we are not, my lord, this departmental head.
But one thing, sir.
The court never said. Court said that subject to this.
Whether it children's park is important or community halls.
My lord, the children's, my lord, it was never a children's park.
No, it was a children's
park. It was no.
Children's park.
My lord,
it was earmarked. It was earmarked for
refugee rehabilitation department. They marked it. Not as per RR portion.
You challenge this order.
Not as per RR portion.
Concerned lordship, kindly protect us for this limited.
And my lord,
only one thing, my lord. May I submit to your lordship, my lord?
Sir, wait, Mr. Kundu, please. In the earlier decision of the division bench, there is one liberty granted. It is not a perpetual declaration or an injunction given. It says the reclassification or handing over or change can be done, provided it is in accordance with law.
Yes.
You challenge this.
From
This
there,
prayer cannot be granted. Please be reasonable. You take those copies.
Yes.
One
thing. Subsequently,
Wait, sir, please hear the order. By this writ petition, the
subsequently plot
petitioner's
has been
grievance is
handed over.
that a land which has been earmarked as a children's park is being sought to be utilized for putting up construction of a community hall.
I know.
There has been an earlier round of litigation at the instance of the very same writ petitioner in WP 9043 of within bracket W of 2016, which was disposed of by judgment dated 10th March 2017. In paragraph 20 of the said judgment, the Honorable Division Bench held that the nature and character of plot being LOP number 494/622, which stands recorded as a children's park in the layout map of Refugee, Relief and Rehabilitation Department of Government of West Bengal, cannot be altered, and no permission can be granted for construction of a community hall upon the said plot without alteration of classification of the plot in strict consonance with the statutory provisions. The learned Government Council has produced certain documents from which it is seen that there has been an interdepartmental transfer of the government land in favor of the Urban Development and Municipal Affairs Department. The copy of such those orders have been furnished to the learned advocate appearing for the writ petitioner.
But nature of land has already been changed in the Porcher record, Lord. It has been recorded.
In the light of the above, the petitioner is granted liberty to challenge the said orders by way of a separate writ petition.
I have handed over all documents.
One thing, I have got a preliminary point in this issue, my lord. This issue of challenge of the land classification can lie before the LRTD and not in the writ petition. Because, my lord, it is.
Yes.
Lordship, may I only
before the LRTD, it can't be filed before this honorable court, my lord, because there is a separate forum created for West Bengal Land Rules Act.
it should be taken up immediately. Kindly grant me a liberty to file an application to challenge this. Otherwise, this point would be coming immediately once the writ petition is filed. The alternative remedy lies before the elected.
Why not?
Now,
Why don't you exercise such?
But I am a public interest litigant. How can I go and approach this?
The record of land has already been changed. Then the procedure is to make application therein.
Kindly assume my situation. I have filed this public interest litigation.
Without knowing anything.
Sir, bolte din.
My lord, Kali, see that he claiming himself to be a
file is challenge the same before the appropriate forum. You
Yes.
file a writ petition, we will
Yes,
see.
if this writ petition pending, Lordship.
No.
Otherwise, Lordship, this point would be taken up. It would,
LRTD cannot take up the matter.
I am now.
It is not as if from 2016 these people are doing it. It is not as if they are not aware.
Lordship, they have done it on 28/6/2020.
No, sir.
These are not available anywhere.
No. Now that you have got it, you advise.
Now, that's why, Lordship, I only beseech your Lordship to consider a situation. Now, today, your Lordship is not entertaining this writ petition.
No. We have only
And
said,
your Lordship is not refusing the interim order also. I am only said that I want an interim order. Otherwise, this entire purpose would be defeated because they will construct immediately. How the parks will be preserved? Now, Lordship, this is the question because even the preservation of the park itself is a public interest. There are Supreme Court decisions
tomorrow itself you file.
Lordship?
Tomorrow you file.
No, Lordship, I can file tomorrow, but the question is subject to the fact that this question, Lordship, kindly, if it is allowed.
The learned advocate appearing for the 8th respondent submitted that any challenge to any of the orders passed by the authorities cannot be made by way of a writ petition, but has to be before the appropriate authority under the provisions of the West
Bengal Land Reforms and Drainage Tribunals Act 1997.
The learned advocate appearing for the petitioner submitted that the petitioner is a public interest litigant and therefore such a embargo will not apply to the public interest litigation. This question is left open.
The lordship is keeping the petition pending or?
No.
My lord, under a compelling
Lordship,
urgent.
deeply obliged. Proceedings has to be altered, and your supplementary affidavit will be running to 100 pages, more than this writ petition, and it will not be listed.
Lordship, I'll file it tomorrow only, lordship.
My lord, under compelling urgency, extreme urgency, my lord, I am losing my possession tomorrow. An interim order by the honorable single judge while directing exchange of affidavits, my lord. Tomorrow morning, my lord, I stand to lose my possession. It was under Group 9. The ordinary honorable bench is not sitting, my lord. I had mentioned it before the honorable judge in charge. Matter kept on Friday. Then, my lord, today, my lord, the matter was heard, my lord. I'll stand nowhere, my lord, if your lordship, my lord, kindly does not grant me leave, my lord, so I can come up to your lordship's lord and make a prayer for protection of my possession. Please, my lord, in the second half somewhere.
Your lordship.
Please, my lords.
No, it is before a single bench.
Group 9 court, Group 9 honorable single judge was pleased to refuse to pass an interim order.
You have filed an appeal.
I'm wanting leave to file an appeal and move that appeal today in the second half because I'll lose my possession tomorrow.
It is arising out of a surface action.
It arises out of an action under the IBC, but where I am the holder of an approved plan. Kindly hear me for 15 minutes and reject me, my lord, if there's no merits. Reject me if there's no merits.
Tomorrow.
My lord, I'll lose my possession
Tomorrow,
at
first
10:30.
case. Who appears for the respondent?
Mr. Shupratim Talukdar is appearing for the respondent. I'll serve him. Shupratim Talukdar, I'll serve.
And then you.
I was there. I was there before the single bench.
It kindly permit me.
It arises from West Bengal Land Reforms Act. And it's a case of a vesting under section 14B3.
Whatever, my lord, if I don't,
which culminates if I'm this possession, that is consequence. I'm heavily relying on L. Chandrakumar.
He will.
So, my lord, this
unable to satisfy
he
your
cannot come, my lord, bypassing.
No one is bypassing. No one is bypassing. If I am unable to satisfy your lordship that I have the legal standing to come up and that if I am barred by any law, lordship will surely, my lord, show me the door with exemplary costs. But I have a case. I can show, my lord.
You are not making any observation.
Kindly do not, my lord.
Tomorrow morning, first case it is.
I leave to file and obtain tender number, my lord. And because we don't have a copy of the order yet.
You have to. No. Without the copy.
No. The copy of the order will be uploaded today in the server. We'll be placing before your lordship. But as it has been passed only one day before.
Today.
My lord, it's been passed 1 hour. It's been passed
the
before
order
1 hour. It's been passed before 1 hour. We'll put it on record.
We have never granted such permission.
My lord, my
it will be uploaded. Probably you make a request to the honorable judge to upload it with the server copy. You file it.
My lord, I'll make an undertaking. I'm giving an
He granted to file with server copy after serving notice on the respondent.
We'll do that.
They have also
let me file. No.
Other applications.
My lord, may I?
They are taking the chance.
No one is.
Lordship. They have not mentioned
only one. My lord, only one. My lord. No, I'm not pushing. Lord, I'm so sorry. I'm only saying that my writ petition will become infructuous come tomorrow morning. Let me, my lord, have, my lord, the privilege of addressing your lordship, my lord, on whatever it contains.
We can only see the correctness of the order passed by the single bench only after going through the order.
That will be there in the memo, my lord. When your lordship takes it up at 10:30, that will be there in the memo. It's my undertaking to your lordship. My lord, a writ petition will be rendered infructuous without it having heard.
You invoke the other remedies.
Your lordship.
Leave is granted to file with server copy after serving notice on the rest.
AST and ASTA leave, my lord.
Your lordship.
AST and ASTA leave.
Yes.
Your lordship, my item number is 40 in today's list, your lordship.
What is the matter?
The illegal firecrackers.
Firecrackers, say.
Yes, your lordship.
40.
Illegal firecrackers manufacturing. That's why we filed but in prayer portion, due to my personal disabilities, the submission was wrong. I want to amend that and serve for fresh copy. Please leave the grant, your lordship.
Mr. Counsel, this already similar relief was sought for. We have disposed of the matter.
Because your lordship, I don't want for NIA or anything else.
Wait. The Deputy Solicitor General appeared. NIA has already gone and inspected. They have also directed that these are the offences to be registered.
Lordship.
By this writ petition, the petitioner.
No, your lordship, I don't want to go on the NIA portion at all. I want to ensure that the the crackers factory should be make a cluster in out of the local authorities, because due to some accident, the local people also has been
Let the
suffered.
investigation proceed, sir. The petitioner, by way of this writ petition styled as a public interest litigation, seeks for certain directions.
Prayer clause does not tally with the our
Yes,
prayer
that's why I
clause, my
want
lord.
to-
Prayer
that's
clause,
why I
kindly see clause.
I mean,
The petitioner,
that's
by
why
way
I
of
want
this
to amend
public
you.
interest litigation, seeks for certain reliefs, which stems out of a blast which occurred in a firecracker factory at Agra.
It's conceived petition.
Though the learned advocate for the petitioner submitted that in the prayer portion of the writ petition, there are certain errors. Be that as it may, more or less identical relief was sought for in another writ petition, and the court disposed of the same, since already investigation has commenced and necessary steps are being taken at various levels. Hence, a separate writ petition, hence another writ petition for similar relief is superfluous. Hence, no orders are required in this writ petition. Same is dismissed.
Deeply obliged, your lordship.
Keep